Hello and welcome to our Spotlight video series where we talk about cutting-edge employment law issues. I'm Tom Spiggle, founder of the Spiggle Law Firm. We help people who've been fired or afraid that they might be. And today I am thrilled to be joined by Heidi Powell, who is one of our longtime paralegals who will now be taking on the role of our legal administrator, which is very exciting. So I'm thrilled to have Heidi joining us today. And I know Heidi is thrilled to be here. So what are we talking about today, Heidi?
We are talking about filing at the EEOC and the difference between when a person files on their own or when they hire an attorney to file for them.
Great. And just kind of to put some context on that for folks who don't know, if you have, for most discrimination claims, particularly under federal law, you have to file with the EEOC or the Equal Employment Opportunity Commission either within 180 days or 300 days, depending on the state, after the last discriminatory event. And you have to do that before you can even go to court. So it's a really important process that we do for a lot of our cases. So take it away, Heidi. How does it work?
So as Tom said, it is mandatory to file at the EEOC if you have a Title VII claim before you can move to filing in court. It's called exhausting your remedies. So if you're a person who wants to file on your own, which you are completely allowed to do, is what you do is you fill out a form. It's a questionnaire for the EEOC. You fill it out online, and then they will contact you. And right now, especially since COVID, the appointments to get an interview sometimes are 3 to 6 months out, and it's been that way since COVID. So it's a much longer process when you're filing on your own, and it's much more difficult to get a hold of people to get done what you need to get done. You're sort of at the mercy of calling them and being put on hold for hours at a time to get a hold of someone. Now, if you file with an attorney, the attorney has a portal where all their cases are. And this is how we correspond with the EEOC through this portal. We do all the filings through the portal. So the process for that is your attorney will fill out what's called a Form 5, and they will have an attachment. We call it Attachment A, which lists basically your story of how you were discriminated against, dates, incidents that occurred, and pretty much everything about your case. And then we submit that to the EEOC as your attorneys. It shows that you're represented by counsel. And then the process it's still a slow-moving process, but much quicker. And the way it works is after you filed with the EEOC, the first step is if your case is eligible for mediation, which most of the time they are, you can go to mediation through the EEOC. Now, it's important to note that you can only do that if the other side agrees as well. So if both sides agree, then there will be an EEOC mediation, which usually takes place pretty quickly. I would say within 2 months, especially if everyone's available right away. If the mediation is not successful, the case goes back to investigations, and then what happens is the respondent, the employer, is asked to provide what's called a position statement. Sometimes that can take a few months because the employer may get extensions, which the EEOC will always grant. So that could take 2 or 3 months, sometimes even longer. Sometimes it happens really quickly. It all just depends on the employer and their legal counsel. Once the position statement comes in, it is sent to us, and we have usually 21 to 30 days to respond to that position statement, and that is called a rebuttal. That is a much more in-depth document that you work on with your attorney. It usually has exhibits, and basically what you're doing is you're rebutting the position statement and saying why you disagree with it, why what they're saying is untrue. We usually provide quite a few exhibits to show our side of the case, and that is sent to the EEOC, and then the investigator reviews that. And at that point, the case can go on for quite a bit longer as the investigation keeps moving forward. The last thing that happens, in between this time, the investigator may reach out to the attorney and ask to speak with the attorney and the client. They might have additional questions based on the rebuttal that we provided. And the very last thing that happens is the EEOC will issue a finding on their investigation, and it's either a cause finding, which of course is what you want, meaning that they found legitimacy in your complaint, or they will issue a right to sue. And a right to sue is a letter that you get that gives you 90 days from the date it's issued to file in court. The important thing is you absolutely have to file in court within that 90 days or your claim is lost forever. So that is how the process works. And this whole process that I talked about can take anywhere from 6 months to 2 years. It just depends. The EEOC can be very unpredictable. But filing with an attorney ensures that your case will keep moving forward, because as the attorneys, we can keep reaching out to them, which we do a lot, asking, where's the position statement? What's going on in our client's case? So it just makes more sense to file with an attorney, but you absolutely can file on your own as well.
Yeah, and the squeaky wheel, right? Often gets the grease. And I think it's also important. You raised an important point. That when you are going in without an attorney, without filing that Form 5 directly, there's this questionnaire. That is not filing with the EEOC, right?
Correct.
We've seen that happen before, where people are like, "Oh, I've filed with the EEOC." Well, no, you haven't, right? Like that's if you're filing on your own, it's an important process. The EEOC personnel will help you get that form filed, but without that Form 5, you haven't filed your case. You haven't, as you talked about, exhausted your administrative remedies. So it's just something to be aware of if you are doing it on your own. And as you say, it's entirely possible to file what we call pro se or without an attorney. A lot of people do that. Just be aware, you've got to stick through until that Form 5 is filed. If you stop, halfway through that process, then you're going to, what we call the statute of limitations is going to run, and you're going to lose your right to bring the case no matter how strong it is.
Yes, and people often do. We found when we get new clients that they will say they filed with the EEOC, and they have a number. That's true. They give you a number, the cause number, but as Tom said, you have not officially filed. It's called an inquiry, and until you have your interview with them and they decide to move forward, because they can decide not to move forward. We've seen it where they say you don't have any case and they don't even take the next step. So you may not even be able to get your complaint in, because then they'll say you don't have a case. If they say you don't have a case, that's it. That's the end of it. If they say you do, then they still have to get the Form 5 drafted, go back and forth, and get it finalized. Whereas if we file for you, the Form 5 is submitted and you are in the system with an actual EEOC complaint. And I've never seen them dismiss it right out the gate without going through the process when you file with an attorney.
Yeah, no, I think that's a great point. Well, I know we could go on for a while on this topic, but since these videos are short, we will stop here. Thank you so much, Heidi. I think this is great information. I hope folks find it useful, and I will let you get back to the next thing on your desk.
Thanks so much. Have a good one.
Bye-bye.
Bye.